No, please, Lord. My Lord, I am checking for listing unlisted matter, my Lord. Bail
When?
application.
When?
My Lord, tomorrow, my Lord. My Lord, the statute.
49 cases are said daily. Already.
My Lord, statutory period.
Monday?
My Lord, statutory period is, my Lord, 60 days. Today is 56 days.
50?
56 days. And co-accused has already enlarged on bail, my Lord. Tomorrow, my Lord.
Tomorrow as the last item we can try.
Oblige.
No, please, Your Lordship. I pray for bail, listing for bail application, my Lordship. It was last posted on 18/4/2024. Kindly list this matter
When?
tomorrow. Tomorrow, my Lordship.
Not
Tomorrow we have already a lot
on
of
13th, Monday.
Monday.
Yeah, please, Your Lordship. Lordship, this is a criminal petition, Lordship. Already have filed. Lordship,
Come nearer to the mic.
Lordship,
Come near to the mic.
already filed.
Hey.
But we already have filed, and Your Lordship, it is criminal petition, Lordship, on Monday, Lordship.
Okay, possibly.
On 15th, Wednesday.
Lord, 15 is the what happened, Your Lordship. This is the proclamation date, proclamation of attachment date. It is the Indian trial court. So, Lordship, kindly
When the next date is fixed?
15, Lordship.
15.
Lordship.
Before the trial court.
Hi, Lordship.
Okay. Monday.
Monday,
Lordship,
13th.
13. Okay.
Yeah, please, Your Lordship. Lordship, I want to mention regarding withdrawal of a matter for tomorrow. Much obliged.
I wish to mention item number 14, CD not received, Lordship.
23.
Interim is there.
Item number?
14, on 4.
Item number?
14, on 4.
1-4.
When to be listed?
No, sorry. CD is not received. Bail hearing matter.
Interim is there.
Interim is there.
On 29th.
Okay, on the pair being made by Mr.
Islam.
Learned Counsel for the applicant, registrar list the matter of when?
On 29th May.
29.
Obliged.
On that day, learned additional PP shall produce the case before this court. And till then, interim order passed earlier shall continue.
Well, may I pray for listing of a criminal revision petition? Any convenient day of the honorable court.
Okay.
On 15th? 15th. My lord, if it is possible on 16th, my lord. Obliged.
Okay, His Lordship, I would like to mention for the listing of the criminal petition, Lordship, which is filing yesterday, Lordship, and the next trial court date is to the 16th, Lordship. Kindly it's either tomorrow or Monday, Lordship.
Tomorrow not possible. A lot of
By
matters.
Monday,
fixed.
Lordship.
Monday we'll try.
Much obliged. Monday, Lordship.
Please, Your Lordship. Lordship, I beg to mention a criminal appeal for listing, Lordship.
When?
Matter is next week, Lordship.
When?
Next week, Lordship.
On
Next week.
17th.
Take a date from me.
I think to mention the listing criminal, Lordship.
When?
Next week, any date, Lordship.
17th.
Obliged. That is, Lordship. Lordship, in connection with item number 19, my lord, I have filed an additional affidavit, my lord.
Item number 19.
19, my lord.
Yes.
May be allowed to bring on record, my lord.
Okay.
Highly obliged. Yeah, please. So I got to mention item number 10, my lord. The matter-
10.
10, 1. The matter may be adjourned 40 days, my lord.
NCB made.
My lord, Youngest Counsel Azhar Ahmed, out of system.
NCB inform question na.
Did you inform the other side?
No.
No. You inform the other side first. Thereafter we'll consider it.
One more item, my lord, item number 16, my lord.
Yes.
Diary notice.
What is your name?
Yeah, Ahmed.
Mr. A. Ahmed, Learned Counsel for
Interim
the
is there.
applicant. Press for listing the matter when?
After 2 weeks.
On 29th.
Is there any interim?
Interim is there.
Till next date, interim order passed earlier shall continue.
Like Mr. Lordship, I would like to mention for, bring for a listing of a criminal appeal, next
When?
week.
When?
Next week, any day.
On
Okay. Take a date from me.
20.
Obliged. Wait, please, Your Lordship, I beg to mention item number 26. I'm praying for a short accommodation in the matter, Your Lordship. Lordship may fix it on a hearing day next week,
When?
or on a hearing day next week, Your Lordship. Or the week after.
Your good name?
Miss Sidas, Your Lordship.
Miss Idas, learned counsel appearing on behalf of Mr.
T. Mahanta.
P. Monto, learned amicus curiae for the appellant. This is list the matter or
28th May,
Uh, I think this
21st May.
20. Much obliged, Your Lordship.
Item for withdrawal. Item number 33.
I'd like to withdraw this matter, my lord, with the liberty to file a fresh if necessity arises.
Mr. Acer Sodore, learned counsel for the accused submits that he has the instruction to withdraw this petition. Accordingly, praise for allowing him to withdraw this. Here is accordingly allowed. This BA instance dispose of on withdrawal. However, liberty will remain with the petitioner to approach this court again by filing a petition.
For motion bail application, item 1.
This item may be take up after some time, my lord, because we are received information, my lord.
Today is
Better
60 or 61 days, my lord.
60?
Yes.
1 days, my lord.
After some time. Phone করিস।
My lord, can it be at 2, my lord?
Yes.
Okay. Okay.
Item number 2.
Very pleased, Lord. Procedure 439 application, my lord. The NDPS Act 22C. In this case, my lord, the petitioner was arrested on 1/9/2024. Subsequently, after
23.
completion of the investigation, my lord, charge sheet has already been filed. And some witnesses has already been examined, my lord. Since last 8 months, my lord, he is behind the bar. But what had happened here in this case, my lord, the police
How
shown,
many witnesses have been cited in the search sheet?
my lord,
How many witnesses cited in the search
my
sheet?
lord, in witnesses were altogether 18 witnesses is there.
18 witnesses.
18
How
witnesses.
many witnesses examined till date?
My lord,
How many witnesses have been examined till date?
5. Only 5
Out of
Five.
18.
out of it, yes. But what had happened, my lord, I like to point out one thing, my
Further,
lord.
let the record come, we'll hear you. Because without calling for the record, we cannot hear the matter.
That's correct, my lord. But in fact, here in this case, my lord, though the police has shown to be recovered some contraband
Hmm.
from the possession of the petitioner, my lord.
Hmm.
But in fact, that was not recovered from the possession of the petitioner, my lord.
Mm.
So is clearly reflected from the witnesses. Out of the 3 witnesses, they are Caesar witnesses.
Mm.
2 witnesses has already been examined. Well,
Okay,
just
oh,
kindly have a
let the
look, my
record
lord,
come.
the page 41.
Without record, not possible.
So, as usual, লেখার পিছতে একটু হেৰি কৰি দিব। SSL কলপটা up to that status record along with
From
scan
the
copy of
email.
the record from
From
the
the-
learned court below. On করা নাই।
On 20/2025. Item number 34.
20, man. 20. Obliged. Wait, please, your lordship.
Yes.
Lordship, pursuant to the my lord's order, Lordship, we have filed the additional affidavit, Lordship. It starts from page 59, Lordship. Now, Lordship, I come to paragraph 4, Lordship, page 61, Lordship.
Over volume. This is second bail application.
Yes, Lordship.
First order is at page number
Page number in the main petition, lordship.
Basically, like,
Page 55, lordship. Relevant page is that lordship 58, lordship, page paragraph 13, lordship.
when this order was passed,
This order was passed
15/3/24. So, after this, barely 2 months elapsed.
Yes, sir.
We have not called for the record.
Not yet.
This is second bail application.
Yes, sir.
Heard Mr. M.K. Bora, learned counsel for the accused, and also heard Mr. B.B. Gogoi, learned additional PP for the state respondent. This application under section 439 services preferred by applicant, preferred by accused, Mohammad Aslam Khan, who has been languishing in jail hazard in connection with Delhi PS case number 33 of 2021 under section 21C and the PSC. Mr. Bora, learned counsel for the accused, submits that this is the second bail application preferred by the accused. And the first one, being BA number 2538 of 2023, was dismissed by this court by the order dated 15/3/2024. Mr. Bora further submits that the ground for filing the second application is, while dismissing the first application, this court was pleased to direct the learned court below to expedite the trial and to complete the same as early as practicable without being influenced by any observation made in the said order. But the learned court below has failed to complete the trial, and therefore the accused approached this court again by filing the present petition. In order to appreciate the submission of learned counsel for the accused, perusal of the record of the learned court below is found to be necessary, and accordingly it is provided that rest shall call for up-to-date status report along with the case record from the learned court below, fixing the matter on
22nd May.
22nd May.
Obliged.
Item number 3.
Yes, Mr. Talukdar,
My lord, I am
you are for respondent.
for the white man. Perhaps it may be disposed of today, my lord. What happened, my lord, my learned friend is the husband, my lord. He did not appear in the court
Eh?
did not appear in the trial court in the maintenance case. My lord.
Hmm.
Though it is specifically stated and observed by the honorable court, learned trial court, my lord, that he did not appear, and twice notice was served, and both the time it was served. He did not appear. These days, my lord, I have come across many cases, my lord. When the husband will not appear, court will be in a position cannot properly guess the assessment of the income and expenditure, my lord.
Hmm.
So give the minimum amount. So there is a minimum amount is given, my lord. Then, my lord, he came again with a application after it being order passed, my lord. Application there to review the same, to hear him, my lord. Here also, my lord, the learned court clearly mentioned how it was served, how he did not appear in the court. So, my lord, he also, my lord, made a prayer that should go as per Rajesh versus Neha. Nobody will come across with their assets and liabilities. So, my lord, in the meantime, interim may be paid, my lord, and maybe retried. I have no objection. With as per Rajesh versus.
Yes, your lordship, I may be allowed to appear your lordship by vacating the expiry order, and I may be allowed to submit my written statement and asset and liabilities, your lordship. That is my very small prayer. If,
No, not a small pair. What was the amount he
My
was
lord,
directed to pay?
1,500 to the wife and 1,000 to the son, minor son. Minimum, because the court was unable to get any proper assessment of his assets and liability. In spite of serving twice notice, he did not appear. So this is most minimum, my lord. That below that nobody can go below par.
at least I may be allowed.
And he has an income of 80,000 per month.
No, Mr. Talukdar, you see, that was not determined on the basis of any affidavit submitted by him.
Exactly, man. He did not appear. And my lord, your lordship is very much aware of many judgments are there that if he did not appear deliberately, court is to rely upon the submission made. Till the court did not done it. Only you have done the minimum, done the minimum. 1,500 and 1,000.
But you saw the judgments?
But today I haven't come with this judgment, my lord. But court has given the minimum, the most minimum amount, 1,500 and 1,000. Let him to pay this and let it appear and
That may be your lordship, but
No,
it's claiming-
if we ask him to go and file a written statement there, we have to set aside this order.
My lord, I will not disagree subject to, my lord, payment, because one year is going on, he has not paid a single penny, and he has filed
No,
cross.
that was there in that order, the quantum was not decided as per on the basis of any affidavit.
My lord, he has also filed many cases against me. If I am in a situation, my lord, a housewife, how can run the cases, my lord? This
There
guy
are
is
4 or 5
school going
cases.
children, how I am to
No.
run myself, my lord? Interim may be paid, my lord, an amount may be paid, and he may be.
No, but that interim order has to be set aside to return the case to the trial court.
Yes, my lord, so it may be partially allowed, my lord, subject to.
What partially allowed?
Yes, my lord, trial may be again.
Trial court will, on his appearance, both the parties have to file their
He is not-
affidavit
my lord, he is
disclosing
not
their
denying-
assets and liabilities.
My lord, he is not denying that I am his wife, he is not denying he has children. He is not denying, my lord, and he is not denying that I am him, I am.
So
living
better you do one thing, we set aside the order, we will return the, remand the case to the trial court. There you file a petition for granting you litigation expenses.
My lord, it will again.
Or
long time, it will
interim,
take
or,
very long time.
or interim maintenance allowance so as to conduct a trial before the court below.
My lord, it will take another long time, will come, my lord. My condition kindly.
No,
please accept my
immediately,
condition.
we will fix a date on which he will appear before the trial court.
My lord.
On that day, you can file the application before
Yes,
the
my
trial
lord,
court.
it may be recorded, my lord. If your lordship is so, my lord, inclined, my lord, may be recorded. So if so filed, it will be considered within so time, my lord. With these observations, maybe, my lord.
No, is it necessary here?
Otherwise, my lord, it will take another long time. He will take time,
No,
come so
will-
and so, my lord. And I am
No,
suffering
no,
very
no,
badly,
no.
my lord. My children is going to school, my lord, unable to pay the
No,
fees.
Mr. Talukdar, you say immediately after filing of such a petition by the wife, a copy of the same has to be furnished to him.
Well, if he
The
appears,
court has to hear him also.
my lord, give the lower court 2-3 months, no problem, my lord. After appearing, another give 2 months, my lord. But give some time limit. Otherwise, it will be, my lord, going on for a long time, my lord, and with no relief, my lord.
Okay,
Kindly
heard
see, my
Mr.
lord.
Espal,
My
Learned
lord,
Counsel
kindly
for
see
the
both
petition.
in both the orders, my lord, the court has
And
specifically
also
find it, my lord.
heard Mr. Talukdar, Learned Counsel for the respondent. In this petition under section 397/401, read with section 482 of the Code of Criminal Procedure. The petitioner, namely Rubul Ali, has put to challenge the order dated 7/9/2023, passed by the learned Principal Judge, Family Court, Nalbari, in Miss Case number 02 of 2023. It is to be noted here that by the impugn order dated 7/9/2023, the learned Principal Judge, Family Court, Nalbari, has dismissed the Miss Case number 02 of 2023 filed by the petitioner for vacating the ex parte order dated 11/4/2023, passed in case number 147 of 2022 under section 125 service.
My lord, paragraph 2 of the impugn or last order kindly may be recorded. Of the page number 25. Page number 25, second paragraph, my lord. The opposite party submits that the notice was duly served upon the petitioner. It is stated that at first notice was served upon the petitioner by delivering the same to his sister Abeda Begum. But thereafter, as per order of this court, the opposite party took step of issuing notice through registered post. Accordingly, the notice of the case number one so and so was served upon the petitioner by registered receipt number so and so. In support of the same, the post receipt and the track consequent report were submitted before this court. Delivered, my lord, both the occasion. Till it's chosen not to appear.
What is to be done?
Only to be recorded, my lord.
Which one?
This part of this.
No, we are not entering into the merit of the order. no?
My lord, it may be as my submission may be recorded.
Which submission
As my submission and pointed out the points.
is
Maybe
it
record.
necessary?
My lord, it will be better. He
Hmm.
recorded. Otherwise, he will again be make it slow and make all the possible
No.
means to make it slow. Man. Non-appearance is a part of tactic
Mr.
to delay.
Talukdar, learned counsel for the respondent wife submits that the petitioner has received notice from the learned trial court. And in spite of receipt of notice, he failed to turn up without any reason. And therefore, the learned court below has passed the impugn order, directing the petitioner to pay maintenance at the rate of rupees
1,500 for wife, my lord, and 1,000 for the
at the
son,
rate of rupees 1,000 for the
child.
child and
1,500 for
rupees 1,500 for the respondent. No, for the respondent number one.
The sole respondent. The
For,
wife.
for the sole respondent. Mr. Talukdar, learned counsel for the petitioner, further submits that he has no objection in the event of setting aside the impugn order and remanding the matter to the learned trial court. On the condition that the petitioner may be directed to make payment of the interim make by a payment of the maintenance amount granted by order dated
my lord.
11/4/2023.
Yes.
Having heard the submission of learned advocates of both the parties, and also in the given facts and circumstances on the record, this court is inclined to dispose of this revision petition by setting aside the impugn order, ex parte impugn order dated 11/4/2023. No. The impugn order dated 7/9/2023. Passed in Miss case number 02 of 2023. And also the order dated 11/4/2023. Passed by the learned court below, directing the petitioner to pay maintenance to the respondent wife at the rate of rupees 2,500 per month. Within bracket 1,000 to the side and 1,500 to the respondent. The matter is remanded back to the court of learned family court with a direction to the concerned parties to appear before it on
Let the slot date may be given.
1 week,
After 1 week, on 20.
20.
20.
And on their appearance, the learned court below shall afford an opportunity to the petitioner to file a written statement, and thereafter to decide the matter afresh after hearing both the parties.
My lords, in as per Rajesh Mathur Sneha, my lord.
And also in compliance with the direction given by Honorable Supreme Court in the case of Rajneesh versus Neha.
And another 2021 2 SCC 324.
It is further provided that if the respondent wife file any petition for interim maintenance, the learned court below shall consider the same in accordance with law.
My lord, some time limit may kindly be given within 2 months or like this. Otherwise, it will go on and go on.
Within a period of 1 month from the date. Miss, your good name, please.
P Sharma.
Learned counsel appearing on behalf of Mr. A. Tiwari, learned amicus brief for the appellant, submits that she has received the photocopies of relevant documents such as copy of the judgment, statement of the witnesses, FIR search sheet, and also the search form. And as such, the matter may be listed for hearing. Accordingly, it is provided that Registrar shall list the matter for hearing. Should we fix a date? Okay,
On 28 May, Tuesday.
28.
Item 21.
May I do lordship? Lordship, my student election on another man. May I pass over for the time?
Lord,
Which
this is a matter on this to that down, they're taking time, my lord. We have been suffered because of, my lord, non-disposal of this matter. There amount of 20 lakhs is hanging only on account of pendency of this criminal petition. Even, my lord, delay has not been condoned. Lordship may take up after some time, my lord. We have some urgency, my lord.
Yes?
22.
Please, it may be password for a time being.
22.
22. Mr. RD is on like court number 14.
Yes, sir.
Orders RD.
Okay.
Lordship, order matter, Lordship.
The
service is completed, that is still looking. Interim pair yet to be considered.
there is no any.
No, on the first order. As per the order dated 2012.
Okay, let him come.
23.
My lord, IA is filed by the petitioner. Your lordship will come to page 9 of the IA. my lord. The last paragraph. Remember, the petitioners are from Calcutta, my lord. They are the directors of a company, tea company. And their manager was arrested in connection with Gingia PS, my lord. Although we are in bail, my lord, pre-arrest bail, we were not been able to appear in the court, police, before the police station, my lord, due to this condition.
This IA is for modification of the condition number 3.
My lord, order dated 5-3, condition number 3, my lord, 8-3, my lord.
So have you appeared before the IO?
My lord, we could not, because we stay in Calcutta, my lord. If we come in connection with this case, we cannot go back, my lord.
Why?
Because this, it will be because of this condition, my lord, even if the
No,
Vishwanath will be the concerned court, my lord.
no, but you have to appear and you have to file a petition before the learned SDGM, and the learned addition, okay, SDGM will grant you permission.
My lord, that is there, my lord, but we are apprehending, my lord, suppose it is not granted, my lord, we will be in sue, my lord. That is the reason we have filed this petition, my lord.
No, there is no question of modification of this order, of this condition. You have to appear.
My lord, we will appear certainly, my lord.
Hmm.
My lord,
And you have to obtain permission from the SSM because Within his jurisdiction, the occurrence took place.
SDC in Bhopal, no. My lord, it will be Vishwanath, my lord.
Yes,
CGM Vishwanath, my lord, not Gopur. My lord. My lord, I have information, my lord, the named accused also granted bail by the trial court, my lord. It will be- All the named accused, my lord. We are the owners of a tea garden, my lord. We stay in Calcutta. We are
no, we cannot treat you differently.
My lord,
Such
I
conviction
understand.
is always imposed.
They can file a petition before the learned judicial
Yes.
magistrate, then they.
You
if-
go and
if
file
that
a
petition is
application.
rejected, then they can come. If that petition is rejected, then they can come also.
Hmm.
My lord, we will see the trial court has granted the bail to the named accused also.
No, how this trial court order will help you? Because you have also been granted bail
My lord,
here in this case.
my lord. Not for modification, my lord, I am just bringing you before your lordship knowledge, my lord.
No, that's why. How this order of the trial court will help you?
Look, we approached this honorable court only apprehending that their manager of the garden was arrested in connection with the PS case, my lord. We were not named, neither we were searched by the police, my lord.
So if you do not appear before the IO, then we will recall our order.
My lord, we will,
Yeah, you face the consequence then. We will recall the
No, we will-
PRS bail order.
my lord, we will appear certainly, my lord. Your
Hmm.
lordship will fix up a date, my lord,
What date?
for fixing the case diary, my lord. In the meantime, we will.
What case there is?
No, it's a night date.
We have already disposed of the bail application.
No, my lord, I am on
Then,
interim bail.
then,
And CD case diary was fixed for CD, my lord.
On what day?
Date গন্ডগোল করলে না, date ছিল 10/5, has come on 10/4.
yes, city received. Not received.
Hyperlocal order to
10/4 time. এটাই petition file করবো করে।
Mr. P.S. Lawford learned additional PP submits that he has not received the case diary. And accordingly, it is provided that Mr. Lawford shall produce the case diary before this court on. When?
2020.
Till then interim order dated 5/3/2024 is then extended. Third, Mr. H. Das, learned counsel for the applicant. And Mr. P.S. Lawford, learned additional PP for the state respondent. This interlocutory application is prepared by the applicant Sanjeev Bhalotia and Keshav Bhalotia for modification of the condition number 3 imposed in the interim bail order dated 5/3/2024. . Mr. Das, learned counsel for the applicant submits that White order dated 5/3/2024, the applicants were granted the privilege of interim periods bail by imposing three conditions, and the last condition was that the applicant shall not leave the jurisdiction of learned SDJM and Bishwanath Sarayal. Bishwanath, no, SDJM M Gopur. SDJM M Gopur. But the applicants could not appear before the police authority, apprehending that in the event of reaching Gopur, they may not be allowed to leave the jurisdiction of learned SDJM and Gopur. And therefore it is contended to modify the condition number 3 as is stated above. Admittedly, the applicants have not appeared before the IO, and also they have not filed any application before the learned SDJM M Gopur for allowing them to leave the jurisdiction of leave his jurisdiction. Under the aforesaid facts and circumstances, this court find no merit in this interlocutory application and accordingly the same instance dismissed. The applicants are directed to appear before the investigating agency within a period of 10 days from today.
My lord.
Kita pakai laro.
Item number 37. As per office note dated 8/5, service report upon the informant and HCR is still awaited. So what should we wait till the report and HCR comes?
Office note dated 8/5/2024 indicates that notice was issued to the respondent number 2 through the officer insert jurisdictional PS. And the service report is still awaited. Further, the office note indicates that scanned copy of the record has not been received from the Court of Learned Additional Session Judge Come Special Judge Pakso Borpeta. Accordingly, it is provided that Mr. B.B. Gogoi, Learned Additional PP, shall obtain the report of service of notice upon respondent number 2 from the officer insert jurisdictional PS. Registry shall also issue a reminder to the learned court below for transferring the record immediately. List the matter on
27th May.
27th.
27. For hearing, order matter, item 24.
My lord, in terms of the earlier order, my lord, I have received the, my lord, translated copy of PW 3-4 and 313 statement of 3 accused, my lord. But, my lord, I am sorry to say, my lord, in this case, my lord, actually earlier I was not there and record was also not there. I have taken the record, photocopy from the, my lord, amicus curiae, which was supplied by the registry, my lord. I have checked in the whole, my lord, there only the exhibits are all there, my lord. But there are all total 8 number of PW witness and 1 DW. No statement of evidence, my lord, in the my lord, copy provided by the registry, my lord. When on that day, my lord, I went to before the registry to take the my lord, translated copy. I requested that that can be provided. No, this is not the order. Order is only regarding the translation. So only 3. I have on the PW 3-4 and 313 of all the 3 AQ. But the vital witness, my lord, PW 1, 5, 6. These are, my lord, total 8 numbers of witness and DW 1. My lord, I need only photocopy, my lord. Otherwise, my lord, it's difficult for me, my lord. She also not have that copy, my lord. I have taken the photocopy from her. Actually, I have come, I have entered appearance, my lord, recently, my lord. Because of that, my lord, earlier long pending case, my lord.
So, you required a photocopy of
Of
PW,
the PW and my lord,
PW1.
my lord, 3 and 4 translate copy is there. Other, my lord, PW 1 to 8, my lord, except 3 and 4 with cross, my lord, and DW 1. Only that much, my lord.
Except 3 and 4.
3 and 4 already, my lord, type copy is given, my lord.
Yes.
Translated copy is given by the registry, my lord. The others in English, but that copies are not available.
And DW also.
DW one that DW.
You received DW.
No, not received. Only one.
Madam, you received the this photocopy? No. Yes, Mr. Dubey?
Lord, I had obtained certified copies where I have got, my lord.
You have received.
Records is voluminous, there's my friends, my lord, even I have copied now.
Are those legible?
My lord,
Those copies are legible.
legible, my lord, what is there from the record only, my lord, I have got the
My
xerox.
lord.
I think we can work it out from this.
Today I have flag mark, my lord, PW 1. My lord, may once look at the PW 1. I have just flag mark, my lord. If my lord can, my lord. In the record, PW 1, I have flag mark, my lord. Serially, my lord.
Considering the time frame of the case, my lord, it
It's-
becomes at times
I'm
difficult
just
to
sorry
have a paper copy, my lord, of this paper book, my lord. Already a matter of 2011. my lord.
Otherwise, my lord, I am also sorry to say, my lord, all pending case, my lord.
Or Mr. You are for the
I am for the appellant, my lord.
Mr. R. Mr. K. Parasar, learned counsel for the appellant, and Mr. R. Dubey, learned counsel for the respondent number
One, my lord.
1, and Madam D. Barpuzari, learned legal aid counsel for the respondent number 3.
Who has
Mr.
this type of,
Parasar,
my lord?
learned counsel for the appellant submits that he has been provided with a type copy of the statement of PW 3 and 4. But he has not been provided with the type copy of the evidence of PW 1, PW 2, PW 5, 6, 7, and 8, and DW 1. And as such, Mr. Parasar submits that registry may be directed to provide type copy of the statement. Oh no, type copy of the evidence of PW 1, 2, 5, 6, 7, and 8, and also DW 1 within One week possible. Weeks. On or before? Weeks before. No, sorted. Are they not very? 24th? No. So 22nd then? 22nd Wednesday.
22nd Wednesday.
Can it be on 28th?
My lord.
2/8, my lord.
Yes,
Wait.
28th May.
2/8. Yes. Let me, if your lordship can indicate, my friend should also get a copy of that. What do they have actually?
No, once we get the copy, then we can provide you.
My lord, I can take it, no problem. No issue.
And then I'll get the translated copy from my friend.
Okay.
Yeah,
Okay.
we'll work out on my side.
Okay, but you take down, no? Then prepare the translate, 2 sets of translated copies of the said witnesses and furnish 1 copy to Mr. Parasar and another copy to the learned legal aid counsel, Ms. Deepa Pujari.
Item 25. State appeal, my lord. I am ready, my lord.
Jail bill.
My lord.
This is jail bill.
No, my lord. Appeal against equitable, man.
None appears for the appellant on call. Recess and leaves the matter after 1 week.
My lord, we are appealing, man.
Oh, you are appellant.
My lord.
Who is the other side?
Other side is, my lord, the accused, my lord.
This
Jayed
is,
Alam, my
this
lord.
is by the state.
Yes, my lord. Appellant is statement.
Third, Mr. B. Sharma, learned counsel for the appellant. None appears for the respondents. On call.
The long pending.
Is P. Roy, who is P. Roy? Miss P. Roy.
Miss Piro. 11.
Miss P. Roy. Respondent.
This be for sure. The Zedalam will even select copy. Standard union is Zedalam also.
Okay.
Contact you for the.
Ever consider some- Okay, we'll take it up at the 2 PM then. You will try to contact the.
Yes, my lord, if possible.
Observe in our foregoing para 49 that the recording of the confessional statement of accused Monukon Bush suffers from no irregularity in absence of any abstract indication, instance of any cause of his making the confessional statement involving himself with the crime. The plea of defense as regards his non-voluntariness carries no force. In one of his pleas, the defense of the accused person, namely Hemosoik and Hemantonath, that the accused Monukon Bush confessed in his confessional statement that he alone caused the murder of the Babu Soikia disease and made the confessional statement before the JMFC Shivsagar, as according to him, 2 other innocent persons had to suffer for him. Against the claim of these 2 accused persons, we distinctly make it clear here that the question number 1 to 10 of the confessional statements are put to the accused making the confessional statement by the recording officer only to satisfy himself that the statement made before him by the accused is voluntary, it carries no force to serve anybody. Hence, the defense plea based on the question is not sustainable in law and as such rejected. This is the, your lordship, this is how your lordship, honorable trial court, your lordship dealt with this, your lordship. Now, if your lordship PW3, that part of the statement of the PW3, your lordship, improved part, your lordship, if we take it away, your lordship, there nothing remains so far as these 2 accused persons are concerned, your lordship. And in fact, your lordship,
Here, whether the court below has relied upon by perusing this paragraph number 51 and 52 of the judgment, can it be said that the court below has relied upon the confessional statement of the accused?
Lordship, in my humble submission, your lordship, the moment the
So
court below-
it appears that the court below has not accepted it.
No, your lordship,
Hmm?
so far as my part is concerned, your lordship, our plea, defense plea is concerned, your lordship,
Hmm.
that we have been absolved by in the confessional statement, and he took up the responsibility upon him. That part has been rejected. But so far as the other part in para 51, your lordship, if your lordship go through again for a moment, your lordship. Para 51.
Hmm.
Your lordship will find that in our, as we have observed in our foregoing para 49, that the recording of confessional statement accused Munukon Boysa suffers from no irregularity. In absence of any abstract indication, instance of any cause of his making confessional statement involving himself with the crime, the plea of defense as regards non-voluntariness carries no force. This was, your lordship, on the basis of the argument advanced by the lawyer, the counsel for the Munukon Boysa, your lordship.
No, that's all right, but whether the court below has accepted it in convicting the appellants?
Lordship, essentially, your lordship, that has been accepted, your lordship, and
Where?
lordship, I will show lordship that, but your lordship, that the
Okay,
fact,
but you show it, we'll resume at 2 p.m.
lordship,
It's 1 o'clock now.
thank you, lordship.
49.
49. Two paragraphs I will show your lordship, 49 and 61.
Yes.
Evidence of PW 13 Srimati Audrey Bhattacharya relates to the recording of confessional statement of the accused Sri Munukon Boysa under section 164 CPRPC. No procedural lapse is apparent throughout the process of recording the confessional statement, starting from the accommodating of reflection time questioning of the accused, that neither he is bound to make the confessional statement nor he be sent to police custody for his denial to make his confessional statement, and the confessional statement made by him shall be used as evidence against him. As the recording of confessional statement of the accused Munukon Boysa suffers from no irregularity, Exhibit 10 is accordingly accepted, your lordship. That is clearly the honorable court below has.
That's all right, but while arriving at the finding,
Your lordship will
whether
kindly
the
come
court
to
below
page
has relied
six-
upon it.
Now your lordship will kindly come to para 63.
63.
He has the learned court below. It is found. Your lordship got it. Para
Yes.
60. It is found in the confessional statement of the accused Munukon Boysa, recorded under 164 CRPC, that the occurrence was a result of previous enmity, of which the prosecution too pleaded, and proved that the occurrence of causing murder of Babu Saika by the accused person took place due to previous enmity. We know that the previous enmity is double-edged weapon. Therefore, we cannot ignore the fact stated by the accused Munukon Boysa in his confessional statement that Babu Saika first assaulted him, and that view of the matter, and also for the reason the attack was without any premeditation sudden, we are of the considered view that the case attack provision of so and so, so and so.
It means that the learned court below relied upon the
Lots,
confessional statement of this accused, Munukon Boysa.
lots. So therefore, your lordship, means my humble submission, your lordship, when he has taken up the responsibility himself, and when questions was put to him, he said that to save the, to save the two innocents from being harassed, your lordship, he has made that confession, your lordship. In this altogether, your lordship, and taking into account the fact that the part pitch step of the evidence of PW3, your lordship, is vastly improved, your lordship, as far as the confirmation given by the PW14 that
Who improved?
PW3, your lordship.
PW3.
Three, the entire part so far as that relates to our presence there, your lordship. These two accused persons, not Munukon Boisar part, your lordship. And your lordship will also kindly come to PW7, your lordship, for a moment, your lordship. Just,
Hmm.
There,
But if we weigh the confessional statement of a accused and the evidence of eyewitness, which one will prevail?
no, your lordship, had it been a case, your lordship, that he has not improved upon his evidence, your lordship, then eyewitness will
No,
prevail.
the thing is that some contradictions are definitely there, but are those on material point?
Lordship, because your lordship, our very presence is given the story, your lordship, that I have Simanto has pushed him to the pond, then she has guarded him, then your lordship, he make a phone call
No,
to.
those are not on material point. The material
Because your
point is
lordship,
at the point of assault, on the point of
So
assault.
far as assault is concerned, assault is, your lordship, admittedly by the Munukon Boisar. Even he has not said that we have assaulted the victim, your lordship. It is not the, even PW3's case is not that we have assaulted. Assault, according to him, also made by the Munukon Boisar. While doing so, your lordship, the appellant number 2 has said that Mar, and the other appellant, your lordship, appellant number 1 guarded the PW3. This was his evidence. It was not his case that the appellant 1 and 2 has assaulted the victim, your lordship. That is not even his case, your lordship. That's why, your lordship, I am submitting that this has materially affected, and your lordship may kindly come.
Yes, Mr.
Just
Sharma,
for a moment, your lordship, PW7.
this record. Yes.
PW7, your lordship.
Record.
He is declared as an hostile, your lordship. But he is hostile by, although, your lordship, by way of contradiction brought in cross, but it was not confirmed to the IOLs. I do not know the informant of this case. I do not know disease Babu Soikia. I know the accused Simanto Nath. I do not know the other accused persons. On 2010, I was working in the house of Hemo Soikia along with Simanto Nath. I was working as a helper and Simanto Nath was working as a mason. Then Hemo Soikia asked us to have lunch. At night, I along with Simanto Nath went to have meal in nearby house. At that time, I heard someone shouting Katile Katile. Then I went to the house of Hemo Soikia and slept there. On the next morning, I, along with Simanto Nath, again started working in the house of Hemo Soikia. Now, even their witness, your lordship, has not confirmed my presence in the place of occurrence, your lordship.
So you are also taking the plea of LIV,
Lordship, that's why, your lordship.
but did you adduce evidence?
DW 1, 2, and 3, your lordship.
Hmm.
3 DWs are, your lordship, there. Who says, your lordship, that DW1 is for Hemo Soikia, your lordship.
Yes. Hmm.
Made it, your
Hmm.
lordship. I know the accused Hamo Soikia, I know the disease Babu Soikia, he was my neighbor. The incident took place in the year 2010. Hamo Soikia does business of fees and he has taken Mitong bill on fees from the government every year before starting fishing. The said bill Hamo Soikia performed some rituals in the year 2010 also in the same manner. Hamo Soikia performed some rituals in the house near the said meeting. In that ceremony, 6-7 numbers of persons attended at about 5:36 a.m. Piran Dr. Pores Deka, Sapithor Gogoi, and many other including same women attended. Say accused Hamo Soikia was present with his family in the said ceremony. Initially, Nam Prasango took place and thereafter Bhagavad Path was done by Nilokboy. After Bhagavad Path was over, there was distribution of prasad and thereafter Bhuj Bhat took place. On completion of the said program, other persons come back for the said place. Still then, accused Hamo Soikia was present in the said program. In the next day evening, police went to our village and police recovered dead body of Babu Soikia from a paddy field of our village. Nilok Gogoi is the brother-in-law of this is Babu Soikia. I have no idea how Babu Soikia died. I have not submitted any document as to my identity that I am Pratik Gogoi. It is not a fact that I have falsely deposed that Hamo Soikia does business of fees and has taken Mitong bill on fees from government. Everywhere before starting fishing in the bill, Hamo Soikia performed some rituals in the year 2010 also in the same manner. Hamo Soikia performed some ritual in the house near said Mitong bill. In that ceremony, 6 numbers of parents of persons as Thopots attended at 5:36 p.m. Biran Dr. Pores Deka Sridhar and many other including some women attended said ceremony. Accused Hamo Soikia was present with his family and the said ceremony. Initially, Nam Prasango took place and thereafter Bhagavad Path was done by one Nilokboy. After Bhagavad Path was over, there was distribution of prasad. Thereafter Bhuj Bhat took place. On completion of the said program about 11:30 p.m. Another person came back from say, it is not a fact that I am relative of Hamo Soikia, therefore I have deposed falsely for court today. In this way, I don't know whether Hamo Soikia can cause any witness in his 307 took any such plea as deposed by me. It is not a fact that Nilok was not.
So what is the distance between the place of occurrence and the place where the witness was at the, no, where the accused was at the appellant was at the relevant point of time?
It is in the your lordship. It was in his home. The rituals, your lordship,
Hmm.
and the place of occurrence is near Mitong River, your lordship. If
So
you
what is the distance?
distance, your lordship, that has not been, your lordship, even brought by the PO, your lordship. The investigating officer, a specific question is put and to him, your lordship, regarding that, your lordship.
Hmm.
With regard to that, your lordship.
No, if you takes the plea of this alibi, then it is your duty to prove that at the same point of time, it is impossible to remain present in both the
Both
places.
your lordship.
That is the principle.
That, your lordship, that exactly that is not there, but your lordship, from the since your lordship, if your lordship goes to the statements, your lordship will find that
So in your 313 statement, you have
we
not
have, your
taken
lordship,
any
only
such plea.
denied, your lordship. In 313, your lordship, we have denied only, your
Hmm.
lordship. So far as this explanation is concerned, it is not there in 313, except what has been brought through the DW, your lordship.
And if you know, you are taking the plea,
Lordship.
then it is your duty to prove that the place where you were at the relevant point of time is far away from the place of occurrence. It is not the prosecution's duty.
That's, your lordship, what has fallen from your lordship, not that absolutely correct, your lordship. But your lordship, the time that has been mentioned here,
Hmm.
that your lordship at till 11:30 p.m. that he was here, your lordship, and that incident PW3 has disclosed, your lordship. His statement reveals that he is at that period of time, your lordship, he was there in the camp in the near Mitong River, near the Mitong River, your lordship.
Hmm.
That is there, your lordship.
No,
And-
the occurrence also took place on the embankment of the Mitong River.
Mitong River, embankment. But my house is, your lordship, apparently, your lordship, from the statements and the your lordship, the sketch map, etc., your lordship, it is not revealed that there are residential houses in the near the Mitong River, your lordship.
Hmm.
That has not been there, your lordship.
Hmm.
That's what, and that question has also, that suggestion is also not there, that it is possible to be there, your lordship. Even. In fact, your lordship, when cross-examination is done, it is only the earlier point is confirmed through cross-examination, your lordship. Now, your lordship, my that it is a case, your lordship, it is nobody's case that that murder has not taken place, the death has not taken place. My case is that, your lordship, if we go to the entire evidences as brought on record by the prosecution, your lordship, then it is apparent that when one person has taken up the responsibility of that he had assaulted the deceased, and that, your lordship, that the only person available for implicating us to the crime, your lordship, is the evidence of PW3, who is supposedly an eyewitness, your lordship, and that part of this evidence being, your lordship, an improvement from what he has stated before the police. Therefore, your lordship, the benefit of doubt should be given to these two accused persons, your lordship. That is my case as such, your lordship. In view of only that, your lordship. Now, had there been this, and your lordship will find that one of the witnesses said, PW1 says, your lordship, that the information was given by Nilo by PW3. If he was the eyewitness, your lordship, he has informed the PW1, then how can it take, your lordship, entire day to find out the dead body, your lordship? He has come, according to PW3 and PW1, he has come directly from the place of occurrence to the house of PW1, informed the PW1, and therefore, your lordship, PW1 says that immediately on the morning at 7, we have find out the dead body. But PW2 says, your lordship, that it was in the evening. At 8, he had went out with his sister-in-law, but could not find out. Then went to the police station. And one witness says that he first saw the dead body and informed the mother of the deceased about the dead body. And mother of the deceased was also not been examined, your lordship. So therefore, your lordship, so far as finding of the FIR was, your lordship, lost at around 4 AM, as revealed by the FIR itself, your lordship, 4 PM, your lordship. Now, as your lordship, these are the, your lordship, discrepancies. If we look at the discrepancies in its totality, your lordship, in entirety, then, your lordship, some doubts creeps into the mind, and if doubts creeps into the mind, your lordship, probably that benefit will go to in my humble submission, to the accused persons, your lordship. These are the discrepancies. Apparently, if we look at the discrepancies isolatedly, then it may not be look like a very big discrepancy, your lordship, vital discrepancies. But if we look at the discrepancies in its totality, your lordship, in its entirety, your lordship, then probably in my humble submission, your lordship.
No, that's all right, but whether the discrepancy is on material point or not, that is the question.
Lordship, and my
Otherwise-
humble submission, into which utmost humility in my command I am submitting, your lordship, that since this is their presence itself comes under doubt, your lordship, in view of the improvement, your lordship.
No, doubt means you have to establish it. You have to
Your
discharge the
lordship, so-
burden that you were taking the plea of LOB.
Lordship, so far as my part is concerned, probably, your lordship, as a defense, your lordship, it is on the point of preponderance of probability. Now, so far as prosecution is concerned, it is beyond reasonable doubt. Now, we can have set up a case.
No, no, how can you say that you have discharged by preponderance of probability also? Because you could not establish the distance between the two places.
Distance I could not, but your lordship, my presence itself, your lordship, from the
No,
even if
maybe your presence may be, but we have to examine the time of occurrence and the time at which you were present at the
lordship, that your lordship will be
place where these rituals were taken place.
taken place. But your lordship, even if we leave, your lordship, that D1, DW, DW3, I leave it, your lordship. Even then, my presence is not confirmed, your lordship, because of fact that, your lordship, the two facts, that only one witness says that I was there, we were there. But that part, that our presence part, that act attributed to us, has not been disclosed to the IO, your lordship, while recording statement under section 160.
No, this PW3 whispered some word against you.
Lordship. PW3, your lordship will
Hmm.
kindly. say-
Yes, let us read it again
Loss,
from the beginning.
loss.
While I was talking to Hemo Soikia, I know the informant Tulumani Soikia. She is my sister-in-law. This is Babu Soikia was my brother-in-law. I know the accused persons. On 2010, I went to the house of my father-in-law, Bhadreswar Soikia, whose house is situated near the house of accused Hemo Soikia. I reached the house of my father-in-law at about 4 p.m. At about 7 p.m., my brother-in-law Babu Soikia asked me to accompany him towards the embankment of Mitong River. I accordingly accompanied Babu Soikia. Both of us were going towards the embankment, and at a distance of about 20-25 feet from the embankment, we meet accused Hemosoika. Hemosoika asked me about my time of arrival in the house of my father-in-law. Hemosoika used to call me Zwai. While I was talking to Hemosoika, he asked me as to was the other person. I told him that he was Babu Soika. Babu Soika was the nephew of Hemosoika, but I cannot say why he asked me like that. At some distance, the accused Munukon Bosu was present. Hemosoika asked Munukon Bosu to attack Babu Soika by saying, Yak Markat. I tried to obstruct the accused Munukon Bosu, but he inflicted blow with dao above his abdomen. Hemantonath caught me and Babu Saik was chased by Munukon Boyse towards the embankment. Then Hemoseke caught hold of me and confined me in a house near the embankment. After about 1 hour, Munukon Boyse entered inside the said house where I was kept confined with a dao in his hand, and he inflicted a blow with.
So where you have enclosed this CDR
That's it. Probably no document has been annexed, I think. I didn't find any
document?
document in the.
Then how this plea will help you that there is CDR?
IUMA, when IU will be examined, probably he may substitute this statement made in the final update. Because Lordship, it is stated that during the analysis of the said mobile numbers, following details were found. They said that were sent to the receiver so and analysis were there. But in document Lordship, I didn't find any document.
So if you have not enclosed the documents, how can you rely upon the same during trial also?
With regard to the present petitioner Lordship, paragraph 88 to 93. Page 42.
Roll,
42.
roll.
Hmm. What is the earlier order?
Earlier the Lordship will find at page
Page
number
number
page number 53 Lordship.
53. 53. So, and the ground for filing this second application is only delay.
Delay Lordship, and the 5 witnesses, they have not stated that from the position of the accused person recovered any contraband. Lordship.
How many witnesses are left to be examined?
Total 11.
Total 11, out of 11 only
Four have been examined.
4 examined, 1 chief has not yet been completed.
And Mr. Kyle, why the court below has not taken recourse to section 309 CRPC in spite of observation made by this court?
Probably record will reveal
Pardon?
the record received from the trial court will
Hmm.
reveal why section 309 has not been taken.
No, you can see the record.
And Lordship, recently, in the case of Allahabad Bar Association versus Union of India.
Cover
That
volume
is
to
after
compare.
this. That is after this order. What my learned friend is going to place before this honorable court, direction should not be passed by the court to
Not only
that court,
this.
trial court lordship. To that regard, lordship, Supreme Court passed an order that lots of works are there in the trial court also, direction should not be passed in every matter, in some matter.
Not
So
only
that-
this, Lordship, let me complete, thereafter
that-
she
no,
will get
what-
chance.
I'll get chance, but here, this is my petition, let me explain these things first.
Then
So in this case, lordship, what happened, lordship pass a direction.
No, no, direction regarding this timeline.
Yes, yes.
That was
But-
in timeline.
but-
But this direction was not in respect of timeline. It was only in respect of taking recourse to section 309.
309 and lordship to that regard, act is very much clear. Section 36 is there, lordship. And you can say 36 one is this. In the act itself, it is stated, lordship, as per section 36 1. 36 1, lordship, may I read, lordship? The government may, for the purpose of providing speedy trial of the offences under this act by notification in the official gazette, constitute speedy trial. My only focus on this speedy trial. The government may, for the purpose of providing speedy trial of the offences under this act. So, for that, lordship, for
You were reading
36, lordship, constitution of special courts. Why these special courts are constituted under this act? Just to with the intention to speed up the trial, lordship. And to that regard, under NDPS Act in the year 2013, lordship, Thana Singh judgment is there. Day-to-day hearing is required in this act without any adjournment, lordship, by the both sides. Resorting 309, lordship.
which judgment?
Thana Singh, lordship, 2013, we have, lordship. Thereafter also 2017 in other cases also apex court passed the lordship. Thana Singh. And in after Thana Singh lordship, our High Court also changed the law. Before 2013, it was the NDPS cases filed by the DRI Customs and NCB lordship. It was summon procedure cases. In the year 2013, it has been changed by the Honorable High Court by the order passed by this Honorable High Court lordship and changed the law, and it makes to lordship warrant procedure. No need to examine before framing of charge, no need to examine the witness, lordship. After threadbare discussion, it has been changed, lordship. Just for the sake of speedy trial, lordship. Lordship will find at page 593 adjournments, direction, lordship. In para 7, 8, and 8, and in the last portion of 8, lordship.
Page number?
Page number 593. Direction regarding adjournments. It is specifically under NDPS direction regarding NDPS Act, lordship. In the paragraph number 8 in the last paragraph, lordship, page number 594, the lordship, the fourth proviso deserve immediate notification in lieu of the LECOLA created by its conspicuous absence, which is interfering with the fundamental right of speedy trial, Husainara Khatun versus State of Bihar, something this court is duty bound to protect and uphold until the statutory provisions are in place. We direct that no NDPS court would grant adjournments at the request of a party except where the circumstances are beyond the control of the party. This exception must be treated as an exception and must not be allowed to swallow the generic rule against grant of adjournments. Further, where the date of hearing has been fixed, as per the convenience of the council, no adjournment shall be granted without exception. Adherence to this principle would go a long way in cutting short the queue of the doors of justice. So it is the direction passed by the court lordship regarding other thing also. Even the FSL expert, their presence is not required by resorting to section 293 lordship. Only the affidavit can they file lordship. That direction also passed in next paragraph lordship. So after that also in Muhammad Hussain case, Hussain not regarding NDPS Act, but overall all the acts accumulated in that case lordship. And after threadbare discussion of all the cases pending before the trial court or high court lordship, a direction is passed. A decision summed up the case lordship and in paragraph number 29. Paragraph 29, after discussion lordship, after all the matter discussed in this case, and then summed up lordship regarding the session tribal case, at what time they should complete it. These are the session tribal case lordship at 29.1.2. Ministerial trials where accused are in custody be normally concluded within 6 months, and sessions trial where accused are in custody be normally concluded within 2
Not
years.
that, this
These are not-
law is no longer holding the field. Because in a very recent judgment, the Supreme Court has said that no timeline can be fixed.
That is in the recent judgment, but the lordship, what happened here, NDPS case, act itself provides that speedy trial is required also. In the Act 36(1) lordship. And
No, our question is, in spite of observation made by this court, why the court below has not following the procedure?
So in this case, charges were framed
Hmm.
on
17/1/2022.
17/1/2022. The last witness was examined on PW5 on 10th of January 2024.
Hmm.
And this chief was reserved for further evidence in chief is reserved. Thereafter, lordship next date was fixed on 27/2/2024.
Hmm. No,
27
day-to-day trial was not conducted.
Yes, day-to-day trial is.
Hmm.
And on 27/2/24, the present petitioner filed bail application. And next date was fixed on 19/3/24. On that day, the bail application was withdrawn. On 2/4/24, bail application was withdrawn. And lordship, I was placing that Allahabad Bar Association judgment. There is Judgment was pronounced by the constitutional bench
Which judgment?
that High Court Bar Association Allahabad versus State of UP.
Hmm.
In paragraph 28, municipal supply the copy. I'm slowly reading municipal supply copy of it because copy is not with me. Paragraph 28, the constitutional bench of this court have considered the issue of fixing timeline for disposal of cases in cases of Abdul Rahman Antule and P. Ramchandra Rao. In case of Abdul Rahman Antule, in paragraph 83, this court thus held. But then the
Which paragraph?
paragraph 28. Supreme Court has considered earlier two judgments.
Which judgments earlier?
Lordship Abdul Rahman Antule
Hmm.
and P. Ramchandra Rao.
The judgment we have earlier relied upon,
Yes, Lordship.
that was discussed.
Yes, that has been discussed. And Lordship finally in paragraph 32. Lordship, here interestingly, the Honorable Supreme Court has considered all aspects of the matter.
Paragraph 30.
And Lordship may come to paragraph 31 also. 31
Hmm.
starts.
50 quarter has been passed.
Oh, is this the impugn order?
Yes, yes, this summons were issued on this date,
14/6.
14/6. The entire order sheet is there, it's just thereafter below the effect till 3/10/2023. The entire order sheet is here, it starts at page 230. It starts at page 238. This is the entire order sheet. What I'm on, the vehicle was seized from some other person, not from the bank. The respondent number 2 says that he surrenders the vehicle. It was a symbolic surrender, without handing over possession. Now he comes with FIR saying that I have surrendered the vehicles, the bank is not entitled to recover any money from. So once we issue notices, he lodges the FIR below, case registered under 406/420. Another below 384. The ultimate charge sheet was submitted under 384 as well.
No, you were in this petition, you were praying for quashing the search sheet,
Charge sheet as well as the proceeding below.
and the order has not been impugned here. 14/6.
The entire proceeding below otherwise. Page 2 below.
And all subsequent.
If you order dated 14/6, so
Okay,
and so.
okay. Heard Mr. D, learned counsel for the petitioner. Office note dated 6/5/2024 indicates that neither AD card nor answered notice returned to the section. Nor answered notice issued to the respondent number 2 returned to the section. Mr. Gogoi, you are for respondent number 1.
One.
Or Mr. Gogoi for respondent number. Scan copy of the record of the learned court below has also not been received. Mr. D, learned counsel for the petitioner submits that by the impugn order dated 14/6/2023, the learned court below has issued process to the applicant, process to the petitioners for appearance. Where is the last order?
Today was the date fixed here, the year below annex date was on 3/10/2023. Page 245 is the last order below, so at the time of filing the case.
3/10/2023.
Yes. We file applications without seeking time.
And that the learned court below insisted upon production of staying or stay of the proceeding order. And further, Mr. Day submits that the court below is not willing to grant further time. And as such, Mr. Day contended to stay further proceeding pending before the learned court below till disposal of this petition. But having heard the submission of learned counsel for both the parties, I have carefully gone through the petition and the documents placed in record. When it appears that on the basis of one complaint lodged by respondent number 2, the officer inserts Dibrugarh Police Station as a registered a case being Dibrugarh PS case number 788 of 2019 under section 420 IPC, and thereafter on completion of search sheet. Now on completion of investigation submitted search sheet under section 120B 406 420 384 IPC against the present petitioners. Mr. D, learned counsel for the petitioner, further submits that the allegation level in the FIR are false and fabricated, and in fact he has not, on the respondent number 2 has not surrendered the vehicle which he had purchased by obtaining loan from the petitioner's company, and pursuant to an agreement enclosed with the petition as annexure 4 at page number 159, the respondent number 2 had sold the vehicle to one Hiran Gogoi. And the petitioners have produced the aforesaid agreement pursuant to the notice received under section 91 CRPC from the officer, no, from the IO concerned. But the aforesaid agreement has not been seized by the police and mechanically submitted search sheet. And thereafter, the learned court below by cryptic order dated 14/6/2023 had issued process to the petitioners. But having considered the submission of learned counsel for the petitioner as well as the learned additional PP. And also considering the facts and circumstances on the record, a prima facie case for granting stay of the proceeding pending before the learned court below appears to be made out. And accordingly, it is provided that further proceeding of GR case number so and so.
PRC case. Actually,
What is the number?
page one, PRC case number 685 of 23.
PRC case number so and so, pending before the court of learned.
Chief Judicial Magistrate Dibrugarh.
Chief Judicial Magistrate Dibrugarh stands state till next date.
Deeply obliged.
List after 2 weeks.
Coming item 25.
Nine. Heard Mr. B. Sharma, learned counsel for the appellant. None appears for the respondents. Though name of some of the lawyers have been reflected in the cause list. This is a list the matter on when?
Three zero.
30.
30 May. 30th May. Item number 29.
My lord, in this case, my lord, I have concluded my argument.
Okay, the original record received.
But LCR was not, my lord, received on that day, my lord.
It was. Oh. Office note dated 6/5/2024 indicates that record of special POCSO case number 12 of 19 has been received from the learned trial court. It is to be noted here that we have already heard learned advocates of both the parties at length. Fix. I don't think that will be clear.
June 1st week.
नहीं argument होना दरकार नहीं तो judgment program. So judgment reserved.
My lord.
Item number 30.
This email petition is against the judgment order of the 3/3/23. Conviction for various imprisonment of 5 years and with fine of 10,000 under sentence of POCSO Act. Initially, complaint was filed.
So you have been convicted under section
10 of POCSO Act.
10.
10,
What is the punishment?
5 years. I'm behind the bar for 421 days.
You are behind the bar for.
421 days.
So instead of this IA, we can finally hear the matter. Okay?
Last occasion, my lord has heard the matter to an extent, my lord, and he was taking a plea of alibi, my lord. On that point, lordship has directed the appellant to address on that issue, my lord.
That
Otherwise, that
alibi
alibi.
point. Yes.
And I have also.
Yes, on the other day, we have referred one decision, this Durnas Pandey.
Yes.
Have you find it?
Pandey, I don't have, but I have got some other judgment.
It's Munshi Prasad, my lord. When it's
Pardon?
Munshi Prasad. 2002-1 SAC 351.
Yes, do not, the-
Name I could not tell you, but I found one is Munshi Prashant.
hmm,
There is the age limit also that has been.
And Dudnath Pandey, judgment is, my lordship, it's 1981 to SCC 166.
yes,
Dudnath Pandey,
yes.
that is there.
The age limit has not been appreciated. They have exhibited two documents, the birth certificate and the HSLC examination. Where the incident took place on 9/2/2020. At that point of time, she was, as per my calculation, she was 16 years, 1 month. More than 16 years. of age.
Yes, she is a child as defined in section 2D of the POCSO Act.
Not-
She has not completed 18 years.
Not complete,
Then,
more than 16 years.
then,
Yes, Lord, that age dispute was there. And then birth certificate that was obtained, that was on, she was born on 2004, it was
Hmm.
obtained in 2015.
hmm,
The PLEV that is, this has been supported by the prosecution witness, Your Lordship, not by
Hmm.
witness. So prosecution witness, those have been,
which witness supported your plea,
you know,
PW?
PW 12, Your Lordship,
PW?
12. 12, 13, and even the investigation officer has supported. Initially, he was accepted
PW 12.
12.
Let us see.
So PW 12,
Hmm,
Pranjal Dotto,
yes,
he states that, I know the informant, I know the accused person. I heard that on the relevant night of occurrence, one of the unknown person came out of their house. I cannot say from whom I heard about the occurrence. The family members of the informant and the accused person had good terms and maintained their relationship. The accused Arup Bora was with me on that relevant night. The accused Arup Bora was my worker. During his
no,
course,
that's all right, but where he was
he was
at the relevant point of time,
a distance away, 5-6 kilometers away, working in a pendle.
working in
Working
the,
a bhaun, preparing pendle for Bhavna.
hmm,
There's
no, when the occurrence took place,
at night, Your Lordship.
at night,
Whole night they were working. On the next morning, they had returned the house. This was stated.
no, where it is stated that for whole night he was working there.
So during the course, Your Lordship,
Hmm.
the police interviewed me. I have stated before the police, the accused Arup and I ate dinner and went to the Bhavna, but Ratan, who is alleged to be the inside the room that the victim girl also, left to his house and refused to go with us. I have stated before the police that Ratan was in the house accused and on the relevant night. In fact, the first, it is the PW 13 year olds is also supported
No, where the occurrence took place?
at home, at the residence of the PW, the accused person,
Hmm.
that is.
No, you say to establish the plea of LEB,
Right.
you have to establish that you were in a place far away from that place, from the place of occurrence.
Lord,
And at the relevant point of time, it was impossible to remain you in both the places.
it was 5-6 kilometers away, the
Hmm.
blaze area.
So is it not possible to come and commit the offense and go back again to the again to your working place?
5-6 kilometers, why with
Hmm.
distance, Lord, in the blaze area where communications little different, difficult.
Hmm.
Lord. And this, his presence was supported by the prosecution witness, not my witness. Your Lordship.
Which one?
The 13 also, this is.
Hmm.
On 9 to 20, accused Arup Bora was with us by doing pendal work on the occasion of Bhavna.
Hmm.
We returned back home after completion of work, our work on the next morning. We had returned the work, returned only on the next morning.
Hmm.
After that, we came to know that there was some occurrence took place. I do not know exactly.
Hmm.
What is, he was along with this present accused petitioner working throughout the night
Hmm.
for Bhavna. Your Lordship. This same has been also been supported by the investigation officer. Your Lordship.
Hmm.
Initially, this present petitioner was exempted from the trial, Your Lordship, by the investigation officer. Your Lordship. Later on, he was implicated by the land court. Your Lordship will also see the oath of the IO, Your Lordship.
Hmm.
We have 94, Your Lordship. The middle portion it is. It is a fact that I have given note in my case that on the relevant day of the occurrence, the accused Papu Bora was in Arunachal Pradesh, who was married the victim. By doing this job, and the accused Arup Bora was busy in pendal work of
Which part you were reading?
page number 94, second paragraph, small paragraph.
The evidence of PW 17.
PW 17,
Yes. Cross part.
crossword. The 94 page number, second paragraph, small paragraph.
Hmm.
It is a fact that I have given a note in my case diary that on the 11th day of occurrence, the accused Papu Bora was in Arunachal Pradesh by doing his job, and the accused Arup Bora was busy in pendal work of Bhavna in Kotania Gaon. Even these are prosecutor witness who has supported my presence away, a distance away from the place of occurrence. Your Lordship.
No, whether this note has any value?
Yes, given an oath before the land court. Your Lordship. Even the cross examination is proposed. Not the case is.
How can the IO give such a note?
Otherwise, he could have been declared an.
Third, Mr. R. Secretary, Learned Counsel for the appellant, and Ms. M. Burman, Learned Legal Aid Counsel for the respondent number 2, and Mr. Gogoi, Learned Additional PP for the respondent number 1. List the matter on.
June 1st.
No, sorted. 28.
28.
Okay.
Item 31.
So time will not permit. As agreed by learned advocates of both the parties, and races shall list the matter on suggested date.
June 1st. 6th June. Item 32. On 6th June. 32.
This constitution analysis whether revision will lie. On last occasion, Lordship has asked me to make research. I found one judgment of our High Court. That it is said that revision cannot be converted into appeal. In 2021. That reported in 2021, 1 GLR page 721.
No, here this revision is not maintainable.
Not meant.
The question was, can we convert it to appeal?
But it cannot be because the section 378 4 against acquittal, leave is required to be taken.
No, but there is one judgment of Supreme Court written by Justice M.R. Shah.
The Lordship told me last occasion, but
Huh.
I didn't find, there are,
You
in
could
this,
not find it.
in this judgment, Lordship, 5 judgment of Supreme Court has been referred in.
No, that is a recent judgment. This M.R. Shah judgment is.
Actually, I tried to find out, but
There is. I have applied that law also in one of the case.
okay.
In which senior advocate Mr. G.N. Sahiwala appeared.
Lordship, I held that the revision is, cannot be converted. No, Lordship,
No, some observations are there on the basis of which we have converted the
revision.
Yeah.
But
appeal to revision or revision to appeal. I have not exactly remembered.
appeal to revision, there is no problem,
Huh.
but from revision.
Revision to appeal cannot be.
Yes, Lordship. Because, I guess secretary's leave is, leave has to be taken.
Have you filed any judgment on that in that
No,
regard?
But
No.
generally it is converted,
Hmm.
revision,
Generally.
revision is converted to appeal, that happens. But appeal,
No, this is revision.
This is
Present one is
This is a
revision.
revision.
So I have the reference, but I have to find it out.
I'll take from the Mrs. Sahiwala, I'll talk to him.
When can we fix this matter then?
Any shortage, because my learned friend is appearing as amicus query.
Yes.
Metro is 2009, had it been a
Yes,
new case, we
2009,
could
yeah.
have filed
Uh,
leave also, but 2009 case, incident of 2005, so almost 20 years.
And
So-
We have to decide it anyway.
Yes, Lord.
Let us fix a short date then.
21st.
Heard Mr. Kyle, learned counsel for the petitioner.
No,
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 you
I-
are for the
Respond.
respondent. And Ms. B. Sharma, learned amicus curiae for the petitioner. List the matter on
21st.
the point of maintainability, for hearing on the point of maintainability.
Much.
Any other, madam?